So, hello everyone. So, I'm going to be taking the topic Duress, Undue Influence and Unconscionable Dealings. And in this topic, we're going to see another type of vitiating elements. And before now, we have there have been some other vitiating elements when it comes to the law of contract that we have treated. We have treated misrepresentation and we have treated mistake before now. And by way of a short introduction, I would like to avert your minds to the element of contract. And if you can remember vividly that when it comes to the element of contract, it has been, the position is that when all the elements are present in a contract, in an agreement between parties, then that will be seen as a valid contract. And the elements that I meant are offer, acceptance, consideration, and as a matter of academics, also intention to create legal relations, which obviously we're able to prove also that it's one of the elements of contract. But then we have over the times, because of in the course of treating the topic misrepresentation and mistake, we had also seen that there are some other elements, there are some other things, other consideration that could invalidate, or would I say that could make a contract void or voidable. All right. So one of them is this topic that we'll be treating. And parties under the circumstances of duress, undue influence, and unconscionable dealings has been able to prove, or if they are able to prove the presence of these elements or of these things that I've mentioned, then they may be able to get such contracts set aside by the court. And although it's not in all cases that these allegations may actually be acceptable, or will I say be sustained in court, there are times that if it had not been properly proved, it may not be sustaining. And so as we go on, we would see that there are times that if economic duress would fly, economic pressure would not fly. And so when we get to that, we are going to speak extensively on them. And I need to also inform or remind you that it suffices to say that each of these concepts above, they are different and they have their separate rules. They are different and they have the rules that sustains them. So the applicable rule under duress, when you are treating it, you should not conflict it with that rule under undue influence and the rule under unconscionable bargains, right? At some point, this part of new and emerging themes under contract law has been developing. It has been like an independent doctrine that has actually been developing independently now. So in our discussion would entail the interaction between the rule of law and the law of equity. And of course, when it comes to law, especially the law of contract, these both principles work hand in hand most times. And that is because we know that when it comes to law, it all started from common law, but then the harshness in common law had brought about the law of equity, which was developed in the Court of Chancery. And so we are going to do a lot more on this, between this rule of law. And the essence of this is so that we know the beginning, we know the history, and we know what is happening presently. So when you know the history of a thing and how it has been applied over the years, and now equity at some point been able to bring about justice, then I think the topic will be very clear. So let's start from Duress. So when we are talking about duress, consent is very important. And that is in all cases of contract. Okay? In all cases of contract, the parties have to consent to a contract, and it must be a willing consent. It should be a consent, because there are times that, and that's how you get to discover that here, that it's not in all cases of consent that you get willingness. There are times that consent are given against the will of the person who had given the consent. And so we'll be doing a lot of that here. So the principal role of duress is to discourage the use of coercion in contractual relationship. So when it comes to contractual relationship, coercion will be discouraged. Okay? So, let me see if I can. So let's go to the ordinary meaning of duress. So what is duress? Duress is threat or force that are used to make somebody do something against their will. And that was how I started it all. An action or a consent, a contract that was executed against the will of either one of the parties now. Now, it is important to say that the meaning of duress is very narrow when it comes to the law of contract. That is in the ordinary parlance. And so when it comes to the proof of duress, in common law, generally, if you are able, you just have to prove threats and force, or would I say coercion. All right. Now, let's take it one after the other. Let's talk about duress at common law and, of course, duress in equity. So when it comes to duress at common law, like I've said, the scope of duress at common law is very narrow, but then it was later expanded, all right? So, and the expansion, you will see it as we're going now, because the expansion, it all started from duress to person, duress to goods. But then at some point, duress to goods was not able to, or could not take a lot of transaction when it comes to the recent economic growth. And so came economic duress. But then, like I said, history is very important. Let's start from duress to person. So under duress to person is the least controversial. It is the least controversial. So it is the least controversial because it consists of actual violence to a person or to the members of the family, or a threat to the person's personal freedom. So in essence, if a person, a claimant or a claimant is able to prove that there was an actual violence to his person or to the members of his family, or where he's able to prove threats to his personal freedom, then at common law, there is no much to do. If a claimant is able to prove all this, he will be granted the remedies, the reliefs that follows such claims. He will be granted the reliefs that follow such claims. And so it's not that controversial. I won't say simple, but then it's not that which would lead to, or that which has led to a kind of big discussion. Because if a claimant is able to prove all these things, I mean, able to put actual violence or threat to their personal freedom, that suffices. So if that is proved at common law, the courts are always open to set aside such contract, especially when it comes to duress to person. All right. And duress to person is it is a traditional duress at common law. So more or less like something, something, I would say it started all from that. It started from duress to person. And so it's a traditional, it has the basis. It started it all right? So looking at the case of Barton and Armstrong, where the threat to kill was uttered, the Privy Council in this case held that the threat need not to be the sole reason for entering into a contract, and that it's sufficient that the threat was one of the factors which influenced the victim, excuse me, to enter into the contract. In other words, the threat did not have to be the reason, it doesn't have to be the reason that that person had come to court. It doesn't have to be the predominant reason or something that you have to clinch on. It could just be part of the reason why that person has come to court, that person has entered into the contract. And the court in this case of Barton and Armstrong held that a contract that is entered into under duress is void and it is not voidable. Take note, it is void and not voidable. As an indication that the law gives zero tolerance to duress to person. And I think I would say there should be no kind of argument regarding this kind of contract. And if you have any, kindly indicate your reaction, or you should state your reaction in class. But then I think zero tolerance to this kind of contracts is a good one. All right. So we have some other authorities to the effect that in the case of economic duress, that is when we get there, the illegitimate pressure must be the significant cause. All right. Remember, we are saying that when we come to duress to person, that threat doesn't really have to be the only thing. It could be part of it. But we are saying when it comes to economic duress, the illegitimate Sorry about that. So I was saying when it comes to economic duress, the illegitimate pressure must be the significant cause. So when we get there, actually, this is just a kind of trying to bring to your mind that if this the case in duress to person is saying, if the position is that that threat doesn't really have to be the only thing that that the claimant assent or agree to a contract. When it comes to economic duress, economic duress has to be the significant cause, all right, of that person partaking in the contract. And so I like you to go through these cases. Case of Dinskal Shipping Company, AC against International Workers Federation, and the other cases. If you're able to get hold of it, ensure that you read and understand, right? Now, that is under common law. We just treated common law position, right? Duress at common law. So let's look at the equity part of it. All right. So at common law, a threat of lawful imprisonment or criminal prosecution would not ordinarily amount to duress. Please take note. Now, there was a position we took in class, but after a careful perusal of this note and this position again, I'm able to add this note to it, and so I'm going to explain it better. But that in equity, a threat by one to prosecute the other for criminal offense could constitute a ground on which the contract will be set aside. So in essence, when it comes to a threat of lawful imprisonment, okay, or a criminal prosecution under common law, ordinarily, it may not ordinarily amount to duress. It will not ordinarily amount to duress. But in equity, a threat by one to prosecute the other for criminal offense could constitute a ground on which the contract would be set aside. Okay, and we said you should look at the case of Williams and Bailey. Now, there's a latter part of this note that we are going to treat this extensively. Okay. So what it means in essence is that a common law. And I'll give an example of this lawful imprisonment or criminal prosecution. There are a lot of times that when a party is not doing what they ought to do, right? It happens among lawyers that we could just write our letters, and in the latter part of our letters, a lot of times we used to write a statement that we are going to sue you to a court of competent jurisdiction regarding this case if the needful is not done. So what we are saying in essence is that when it comes to law of common law, under common law, this necessarily will not amount to duress. Because there are times that some people want to do something and they will not do them. And legally, we are permitted to do things, to write letters to them, and more or less like giving them a pre-action notice that if the right thing is not done, we are going to sue you. We are going to take legal action against you. Right? That is under common law. But under the law of equity, that kind of a threat to prosecute the other for criminal offense at times may constitute a ground on which contract will be set aside. All right? That's under equity. So let's then look at duress to goods. To start with, duress to goods was not regarded as constituted duress from the beginning. It didn't start that way. In the case of Skates and Bailey, it was held by the court that an unlawful detention of another person's goods does not constitute duress. And one could see from there that, that's quite unfair. That's quite not, when you go to court to get some form of relief, when you're expecting the court to protect you, when you get there, the court was enhancing the other party who is wrong, then what's the fate of a common man? Anyway, it only started that way. That's not to say that the law over the years hadn't corrected itself. And, a lot of times this case has actually been criticized, and also it had been departed from. And so we have the case of Occidental Wild Investment Corporation, which we are actually going to be talking a little bit about later. Also in the case of Maskell and Horner. In the case of Maskell and Horner, is a case of toll where a toll was levied on a plaintiff under the threat of seizure of their goods, But immediately these people discovered that this toll was levied on them, and if they didn't pay, their goods would be seized. They went ahead, the claimant went ahead to make payment. The position of the court in this case, the court held that the plaintiff was entitled to recover the payment that he had made under such threat. Or it's a threat when the person is saying they will seize your items, actually threat, threat to their life, I would say threat, and so they want to quickly make payments so that they are able to get their goods out of the possession of those people. And so the position of the court was varied, or was a total departure, departure from this case of Skates and Bailey. Or would I say and Bale? And so, due to initial narrowness of the doctrine of duress at common law, a lot of plaintiffs were then constrained to resort to the law of restitution, because initially, remember in the case of the narrowness of it doesn't encompass a lot of things. It just says if you can prove threats, coercion, if you can prove threat to life and all of that. But what of in cases where that cannot be proved? Well, then it was still a form of duress. So what parties had resorted to was to resort to money paid. They go to court for restitution and claim money paid under protest for release of their goods from unlawful detention through an action for money had and received. But then this was just like merry-go-rounding, going a long way, where if there's a position, where there is a case, if there's an opportunity to prove a straight duress, you won't have to be going around proving and all of that, So, with this case, for example, with this Maskell and Horner case, where a plaintiff was able to prove, as against the case of Skates and the case of Skates and Bale, where a plaintiff was able to prove in the case of Maskell and Horner that the defendant had threatened to seize their items, then parties and the claimant won. Parties as from then now say that now sees that the law had recognized doctrine of duress to goods, and so they were able to go straight as against going merry-go-rounding through restitution, through the means of money had and received, So duress at common law, which is otherwise known as the legal duress, is limited to actual violence or threat of violence. So these types of duress hardly come up recently. And anyway, it's not as if it's a total position, because we cannot strictly say that it doesn't exist again. But we would say that in most cases, you rarely see these kind of cases. I mean, this case of threats, of actual violence to persons or to their goods in recent times. And so duress has come in another form, and that is economic duress. And we say that economic duress is more subtle. Economic duress is more subtle as against to the duress to persons and duress to goods, which has to do with threat, with force, with coercion, and all of that. So this third type of duress is very difficult to establish in court because it is more subtle. It is like it's subtle compared to the first two that we have earlier mentioned. So economic duress arises where one party uses its superior economic power in an illegitimate way so as to coerce the other contracting party to agree to a particular set of terms. So there are a lot of times that in a contract where a person has a higher opportunity, a better opportunity from the other, they tend to use that opportunity against the other to get more from them. And so in the case of Occidental Worldwide Investment Company against KIPS, normally we used to call its alias as Sibion and the Saboteur. In this case, the court held that plea of compulsion or coercion will be available where a person was forced to enter into a contract under an immense threat of having his house burned down or their valuable slashed. So let's look at the judicial basis for this. And before we go ahead, it's good to look at this question. Which says that, on what basis did the court intervene to set aside a contract on the ground of duress? So having this in mind, let's then look at the fact that the answer to what we just said to this question is that duress itself has vitiated the consent. That although this person consented and they gave what they expected or what they were asked to, but then they did that under duress. All right. So according to Atia, in reality, it is wrong to say that duress deprives a claimant of all choices, but merely presents him with a choice between evil. So is in essence, what is wrong with a contract is not the lack of a will, but the wrongful nature of the type of threat which had been used to bring about the consent. So the rationale for this is not the lack of will to contract, but then the intentional submission that arises from the realization that no other practical choice was open to them. I mean practical choice. At times there could be other choices, but then those choices may not be practical. And that's what Atiya was saying, you know. A lot of the times it's not as if there's a cancer or that there is no choice at all. But then that at least the choice that could be practical, they are very difficult ones, The choice that could be practical are they are limited, or they are those that, like you said, is a choice between evil, So the threat here, when it comes to law, since the plaintiff consent was procured through illegitimate pressure, the consent is treated as voidable and not, something that can be revocable, but not void, like we would have it under duress to persons, that we had mentioned earlier, and it is revocable or voidable unless approbated expressly or by implication after the pressure has ceased to operate on the victim's mind, So going forward and trying to explain this further, and like we would know that under the law of contract, cases are very important. It helps us to understand the case better. So let's look at the case of North Ocean Shipping Company Limited and Hyundai, or Undue, like I was corrected. Anyways, so in this case, Undue was granted a contract by the claimant, and the contract stipulates a set of stipulates that the claimant likes for the defendant company to build them a truck, more or less a carriage truck, and with that they are going to make payment 5 installments, and the party had already also stipulated the date of the delivery after the truck had been constructed by the defendant, and they agreed to the price. After the first installment, it was discovered that the dollar which they actually use in calculating the amount of the contract had reduced by 10%, or had devalued by 10%. So the defendant company communicated this to the claimant and said they would like that the claimant increase or make adjustment to the price by the 10%. But the claimant company rejected their proposal, and made the following 2 other installments using the earlier agreed amount or earlier agreed installments. So at some point, the defendant company told the claimant company that, and they gave them an ultimatum. You didn't give us this money, we are not going to go ahead, Go ahead with these contracts, or go ahead with building the truck. But then the position then was then that, the claimant company has no other option but to feel you can't just come up with this kind of proposition. We need to sit down at the table to renegotiate. And so they invited them for an arbitration to resolve the issue and go ahead with the contract. But the defendant company will not agree to the idea of arbitration. But because the claimant company also have had another contract with another company, a contract of rentage, they like to rent the truck after the production or after they have been given delivery of the truck. Because of their subsequent contract, they went ahead to make payments. The last two payments to the defendant, and the defendant actually delivered their items, the truck. But one would have thought that the claimant would, because of their grievance, would have sued the claimant, would have sued the defendant as at immediately they received the truck. They didn't sue, they actually sued after 8 months. Now, the position of the court held that another demand for 10% increase did amount to economic pressure, and it made the contract voidable. However, the plaintiff had lost their rights to set the contract aside. They did this by having waited for a period of 8 months before seeking to set the contract aside and claiming overpayment. And the question that arises, is this good law or bad law, Because with all the ingredients of economic duress, which has been proven by the claimant in this case, the court was then trying to, or the court exonerated the defendant based on the timing which the claimant came to court. Now, this argument would be subjective in nature, as everybody would have their thoughts regarding the position of the court. Also, a contract was set aside for economic duress in the case of Universe Township of Monrovia against International Transport Workers Federation. More or less, the defendant trade union in this case was blacklisted. Or would I say the defendant blacklisted the claimant, blacklisted their shift from using a port, and that until they had made some payments, they will not allow them. The claimant company at the time of the request for the money quickly made the payment and then sued subsequently. And the court held that the will of the owner had been coerced. And so that's the reason why they could make the payment, that they made the payment under coercion of their will. And so if you can, see that is the case in this case, it was actually said that the duress, undue economic duress was set. In a case where economic duress had been discovered, the case was set aside. So one party may threaten to breach an existing contract unless the contract is negotiated in its favor, and the other party acceded to this demand in order to avoid the adverse financial consequences which would result from the threatened breach. And so, more or less, someone breached the other. And someone who knows the repercussion of not quickly consenting to some threats, would quickly consent to that and can come back and sue for economic duress. We also have the cases of Atlas Express Company Limited and CAFCO, the plaintiff had erroneously estimated, this is the case of a defendant who had agreed to supply basket wares to a chain of retail shops, and it made contract for its delivery with the plaintiff. But then the plaintiff didn't do his calculation properly. And so at the time when they then came back to realize that they had made a mistake, they actually approached the defendant and informed the defendant. But then the defendant company sent an empty truck to the plaintiff with a message that unless the defendant agreed, the truck will be driven back to them. The court in this case held that the terms were agreed under economy duress, and therefore it is voidable. So to just do a brief summary again, in this case, the defendant had agreed to do some supply, and will be transporting the items around, But then while they were doing their calculation, they had made there was a little bit of mistake here and there. And so the plaintiff made some mistakes, and by the time they informed the defendant, who doesn't want to hear anything, actually said, if you will not do the right thing, I'm going to send this truck. If you will not do the right thing, then you are not going to transport as we've agreed. So under that pressure, or would I say under that duress, economic duress, they went ahead with the contract. And the court held that the terms were agreed under economic duress, and therefore it is voidable. Also, we have the case of the Universe Sentinel. The court in that case held that the ship owner consent to make a payment was obtained under economic duress. Going on, we also have the case of B&S Contracts and Design Limited against Victor Grain Publication. Where in this case, the contract was for the erection of stand for an exhibition. There was going to be an exhibition. And so the defendants were contracted to erect some stands for the exhibition. And so the defendant subsequently asked for an additional payment, and they threatened that if the claimant will not pay the additional payment, then they will not erect the stand. And the claimant had seen that this could affect the exhibition, it would affect the whole essence of the exhibition. And because the claimant actually do not want to fail on his promise to other people or on his contract with other people, he went ahead with the contract. And so subsequently, afterwards, they sued the defendant, and the court in that case held that the money paid was paid under duress and it is recoverable. And so with these cases that we have cited so far, we have seen the instances where the court upheld the allegation, the claim of economic duress. Now, going forward, let's then distinguish duress from legitimate renegotiation. Sorry, please. If you can remember that in the case of Occidental, in the case of North Ocean Shipping Company and Undue, if in that case, Undue had agreed to an arbitration where they can sit down to renegotiate. There may actually be no instance of economic pressure. Remember, I said there may, no, because they would have sat down to renegotiate and would have agreed together on something. All right. And so that's why we are trying to treat and look at the distinction between duress, where duress can be distinguished from legitimate renegotiation. So most of the cases on duress relate to attempt to vary a contract. You know, what we have been doing so far is an attempt to say, oh, this was the position before, we'd like to change the position now, right? And most of it, they came about as a result of some form of economy, things that were unexpected, increase, like the case of 100% devaluation of dollars, which we experienced in the North Ocean and Undue case. And so the parties want to vary their contract. That has been one of the things that has been predominant, you know, when it comes to economic duress. There are times that both parties actually vary a contract so that they can realize and irrespective expectation. And so we have this in the case of Williams and Rofe brothers. Actually, in this case, the defendants, a building construction firm, they had a contract, but then they awarded the carpentry work to another person, who is the claimant in this case. Also, when he was doing his calculation, he underestimated the real cost. And at some point, he also could not manage the workers that were doing the work on site. So at some point, the defendant noticed that actually could affect the result of their work. You know, they actually would be reporting to some other people who had given them the contract. So based on that, the defendant company called on Williams and tried to sit down with him to renegotiate. You know, they tried to renegotiate and they say, oh, that if he's able to complete, they are going to give him, that in order for him to complete the carpentry work as a went due or to complete it, that they are going to increase the money that had been given to him, and they are going to pay him an extra £10, £10,000, £10,300, and that they can even allow him work consecutively with their own client, as against when they allow him, because he had actually taken much time. You know, all of this was so that they can easily and deliver on their own part to the initial contract they had with their own client. So all of this, Mr. Williams did all he needed to do, and he delivered. After delivery, they refused, they didn't give him the additional $10,300 or pounds now. So he sued them to court. And the court in this case held that the performance of an existing duty was, no, anyway, that was an earlier case. The court in this case decides that the trial court held that defendant received extra benefit, which constituted sufficient consideration for the extra payment. So the Court of Appeal distinguished the case from the case of Stilk against Midrick. All right. So in the case of Stilk against Midrick, the court held that performance of an existing duty was not good consideration. But in this, our present case of William against Rofe brothers and Nicholas, the trial court held that the defendant themselves had received extra benefits, right, which has constituted sufficient consideration for the extra payment. And so the Court of Appeal distinguished the case from the case of Stick against Midwick and some other cases for absence of lack of, another cases on the basis of the absence of lack of duress. Now, in those other cases, there was no duress. There was no duress in those other cases. And so the court was able to distinguish this case from that other case. And so therefore, the economic duress must be distinguished also from legitimate renegotiation of a contract. All right. So also, we like to do a distinguished duress from commercial pressure. And so that's, remember, earlier I mentioned that in the case of commercial pressure is quite different from economic duress. All right. So we are going to treat this, and we say that the courts refused to uphold the claim of economic duress in the case of Pao On versus Lao Yun Long. So, and court was able to do that by distinguishing between economic duress and commercial pressure. And so one could see that in this case, it was just a case of both parties trying to be smart. All right. Both parties were actually trying to be smart. Now, the claimant, in this case, they were like, they more or less have their own company, right? Hold on. More or less like a private company. And the defendant were majority shareholder in a public company. And so their intention was that if they are able to buy the claimant company, now the claimant company has a property. And so they know if they are able to buy the claimant company, by buying the company, they also buy the assets. And so they made the proposition. There was a proposition that if they buy the claimant company, they will give the claimant the part of their shares in a public company, which the defendants were, which they were shareholders there. But in order to do that, there was this contention in the fall of shares that they do not want the shares to be devalued. And so the agreement was that in order to go, in order not, so as not to have a devalue of the shares, the party agreed that the plaintiff, remember, it is the plaintiff that own a private company that the defendant are interested in their property, that the plaintiff will sell their shares for a period, will not share their shares for a period of 1 year. And that the plaintiff, subsequently, the plaintiff realized that the defendant may profit from this agreement. They also have a review. They asked for a review of the terms of the contract. And they were trying to be careful against the fall of shares, in the public company as well. So they went ahead, and got a review, but then subsequently there was a fall in the shares as predicted by the parties. So the defendant in this case refused on the ground that the consideration for indemnity agreement was passed and that they had agreed to it under duress. Now, the position of the court was that there was no coercion, but was just a mere commercial pressure, which does not constitute duress. That was just an ordinary pressure and that it hadn't constituted duress at all. Now, the court stated that it is material to inquire whether the person alleged to have been coerced into making the contract did or did not protest. Whether at the time he was allegedly coerced into making the contract, he did or did not have an alternative cause open to him, such as adequate legal remedy. Whether he was independently advised and whether after entering the contract, he took steps to avoid it. So those are the things that the court would look at. All right. But then one could see that in this case, the defendants, they were so interested in that property that they were ready to say yes to anything that the claimant would propose. And because the claimant also, they are trying to be, they are trying to guide against loss on their side, a loss that they will lose and the other party, the defendant, would profit from such loss. They were trying to guide against it. And the court, in this case, defined such kind of review or concern as economic pressure. Now, it's just a pressure that's in contracts. We try to say, because of this, we have to make it this, So they are just trying to guide against to protect their own interests in the contract. And the court said it wasn't duress, it was just economic pressure. All right. So at your leisure, I would like you to compare between the case of Pao On versus Lao Yim Long that we just mentioned quite long, and the case of North Ocean and Undue. Do you agree with the court that in one there was economic pressure and in the other there was economic duress? Do you agree with the court? Let's discuss in class. So then, let's look at threats of lawful action. We have mentioned this when we're trying to differentiate between common law and the case of equity, where I also mentioned that there are times that lawyers make such threats in their letters, especially in cases where a person has defaulted in their end of in a bargain or in a contract. So anyway, most of the time, these things are things that follows, things that follows where a defaulting party defaults. What you do as a lawyer is to sue them to court. And I would say a lot of these things may not seem to a lawyer as a threat. It's just a reminder that do not forget, I'll be taking you to court. That's what I would think. That's the way I would put it. So what then is the effect where this threat is lawful, for example, of litigation, prosecution, or other form of legal action, like I've earlier mentioned? Is it a question of fact? So it is typical of lawyer, like I said, to threaten here and there. Now, it is arguable that contracts reached following such a letter can be voided under the ground of duress. Now, it is arguable. It is not total. That means one can argue at some point that it's not because you are threatening the man, he wouldn't have entered into that contract. So it is not ordinary duress to threaten to do that which one has a right to do. For instance, to refuse to enter a contract or to terminate a contract lawfully. So in the case of CTN Cash and Carry Limited against Calgary, a wholesale buyer of cigarettes, he followed an honest but mistaken demand by the seller, and he paid a sum not due because the seller had threatened, as he was entitled to. The seller was actually entitled to threaten that. To withdraw credit facility from the buyer could not recover on the ground of duress. Now, the Court of Appeal in this case held that although the threat was highly coercive, it was not improper. It was not improper because the agreement could have been, oh, we are going to pay at this point, and if I don't pay, you can do whatever you need to do. I'm assuming anyway. And in this case, he had threatened that he's going to withdraw his money. Like, for example, I'm going to use the example of a bank, where a person borrowed money from the bank and he gave his house as collateral, and he had defaulted in 3, 4, 5 installments. And the bank sent a message to him saying that we are going to sell your property if you will not pay our money. So can you actually say that is a threat? Let's meet in class if you have an alternative opinion, if you have something, if you'd like us to discuss on it. So I'm sure you can get this textbook in the library. Share and 5 foot, you get it in the library. If you can read the case of, you get that case in that textbook. We also have the case of Leyland Limited and Automotive Products PLC. Okay, so we said the exceptionally, a threat of lawful action may constitute duress and render a contract voidable. Okay? In some exceptional cases, not in all cases, all right? So a common law, a threat of lawful imprisonment, like we have earlier mentioned, e.g. of criminal prosecution, will not ordinarily mean duress. But under equity, a threat by one party to prosecute the other for criminal offense could, we are not saying will, we are not saying shall, we say could. It's probable that it constitutes ground to which a contract may be set aside. Okay, so it would be nice to look at the case of Mutual Finance Company Limited and John Wetton and Sons Limited. Also in the case of Ports Caledonia, it was reported a refusal to rescue a vessel in distress or those on board except on extortional term had led to resulting contracting as led to the resulting contract being set aside. This actually, one can see that in this case, it actually shows some form of duress, trying to help people in time of distress and asking them for money, that you don't pay this, I'm not going to help. Even if it's lawful, maybe that person ought to have done that before that. That could actually be seen as duress. So one of the factors that the court usually take into consideration when um, considering whether the victim was indeed coerced is the existence of an adequate alternative remedies. So if the person actually have an alternative remedy, the court may not allow for economic duress. And so it's only in cases where there are no adequate alternative remedies. I want you to take note of this adequate very well. Take note of adequate, because it actually says a lot about the whole thing. There may be an alternative. There may be an alternative, but then the alternative may not be adequate. But then the position of the law is that if there are other adequate alternative, then a claimant may not be granted relief under economic duress. We should also see the case of Atlas Express Limited against CAFCO. Also, where an adequate alternative exists, the court may hold that there is no economic duress, like I've earlier said. So it's better you go ahead, read all these cases for your better understanding of duress, especially economic duress. Now, let's move on to undue influence. So what then is undue influence? So duress is more of a common law thing. But then there are features of equitable intervention in it. You know, we have mentioned a kind of some form of equitable intervention, and even under duress. But then it's more or less like a common law thing. And so because duress is form of narrow, so equity developed its own doctrine of undue influence. And so we can see it in constructive fraud. You know, you can see a lot in constructive fraud. So the court exercises its power to prevent a man from acting against the dictates of his conscience as defined by the court. All right. It's good to look at the case of Norton against Lord Ashburton. Now, undue influence, although undue influence is a well-worn phrase, I mean, it's actually been here for, you know, it has been well, we have plethora of cases on them where court has made several pronouncements. Now, its meaning is quite unclear, you know. No, it's quite unclear, and we don't really have a form of meaning to it. And the question that comes to mind is what does undue mean? What is the meaning of influence? Does it mean pressure, or is it more subtle? Is it a form of subtle dominance? You know, the courts have not really provided clear answer, or hasn't provided clear definition of what undue influence is. So the scope of duress and undue influence overlaps. And so it is important to know that the doctrine of undue influence was developed by the Court of Chancery. And so we know that's the Court of Equity. They developed undue influence. So in the case of Alcard against Kina, the court stated that some unfair or improper conduct, such coercion from outside, some overreaching, some form of cheating, and generally, though not always some personal advantage obtained by the guilty party. And so the court in this case tried to say that undue influence seems to be something that is unfair. It could be an improper conduct. It could be a coercion from outside. It could be an overreaching of one of the party. It could also be a form of cheating. Although in all cases, it is not cheating. And at some point, it's not even in all cases that the parties that did it actually benefited from it. Okay. So the doctrine was accurately stated by Ashburner on equity. In this case, here, Ashburner on equity stated that in a court of equity, if A obtains and benefits from B, whether under a contract or gift, by exerting an influence over B, which, in the opinion of the court, prevents B from exercising an independent judgment in the matter in question, B can set aside the contract or recover the gifts. Moreover, in certain cases, the relations between A and B may be such that A had peculiar opportunity of exerting influence over B. So if under such circumstances, A enters into a contract with B or receives a gift from B, a court of equity imposes upon A the burden if he wishes to maintain the contract or gift. So of the A would have to prove that in fact he exerted no influence for the purpose of obtaining it. And so this is more or less a situation where one has an influence over the other. And the influence doesn't really have to be of a very close relationship at all. It could even be an influence of opportunity, where the other has a better opportunity, where the other has the better information, where the other party has a better understanding than the other, and the other party entered into a contract with them and they got something from them, from the person that was influenced now. Now, it will be in the onus will be on the person who gained, who had influenced the other to come and prove that, oh, I didn't influence them, If he's able to prove that he has exerted no influence, then undue influence will not stand. So then, and so the court also over the years has been careful as to not prescribe the exact limits of the terms on undue influence. So I would like that to look at undue influence under two headings. And the first heading is where there is no special relationship. like we have earlier said, it doesn't really have to be, you don't have to establish relationship at times. You may not have a relationship with the other party. And so we are treating where there is no special relations. So in a case where there is no special relationship, the party that is alleging undue influence will be the one, the victim will be the one that will come and establish it, because there's actually no relationship with them. He has to prove the fact and how he was influenced by the other. So actual undue influence comprises over acts of improper pressure or coercion, such as unlawful threats. Remember, or take note of unlawful threat. So if the victim is able to prove that the defendant exercised a dominant or a kind of domination over their mind and over their will, then the decision of the claimant or decision of the victim will then be seen as to have been influenced. All right. And so the victim, who most of the times are the claimant, will be entitled to the relief on the ground of undue influence. And so I want you to read, aside from all this summary I'm giving to you in these cases, it will be proper that you also take your time to read these cases all by yourself. You can check it in Sage, you can get it in Chair and Chicher and Fivefold, a lot of contractors work in the library. But in the case of Williams and Barley, the father was frightened by the implication of, there's this man, the child of a man who has been presenting several promissory notes, more or less like a bank check. And those checks would not, those checks were not real, more or less like the checks were bouncing. So at some point, the father of the man went to the bank with the man. And so when they got to the bank was then trying to threaten, they said they would jail the son of the father, and they used this term. The banker that was actually addressing them he said that, anyway, the defendant, the son of this man, had actually been forging the signature of the man. He has been forging the signature of the man. And that is why they actually they claimed that if he had been forging his signature, it's actually a criminal offense, and they were trying to threaten to get him arrested and jailed. So the man, based on this, on the position of the bank, said, he then mortgaged the property to the bank based on that threat. All right. But subsequently, it was discovered that there was an inequality between the parties. And so the claimant, which is Mr. Williams, was influenced by the statement that was made by the bank that they are going to get his son arrested. So the agreement was set aside. The agreement was set aside. Okay. So let's look at in a situation where there's a special relationship. And that's where we have the case of Tate and Williams. If you can remember this case vividly, it's the case of a teacher. The case of a teacher who bought the property of a student because the student at some point was going through some emotional problem, was emotionally down at some point. So he met with his teacher and, being the teacher, he highly respected him and he felt, he was indebted at that time and he likes to sell his property. So the teacher brought the property from him. In fact, the property that he bought from him was lower than the normal rate. In fact, he could have sold the property twice the amount he sold it to the teacher. And so after the death of the student, the estate of the student sued the teacher based on the fact that he influenced his decision to sell. And so the court upheld and stated that actually the teacher was in the place of influence and he hadn't used his influence properly. He influenced the student to sell the property to him. And so, how was the position there? And so we say equity would presume the existence of undue influence in cases that exist between people that has confidential relationship. All right. You should also read the case of Powell and Powell, Morley and Logan, Sutton against Patton or Spanny, and the case of Lloyds Bank against Brody. A very good case that you should read. And we also have some cases where the doctrine of undue influence was unsuccessful. So in the case of William and Franklin, undue influence was rebutted on the ground that the defendant had independent advice and that the terms were fair, among other things. That aside from the advice he got from that person that had confidential relationship with him, someone else had advised him independently. So it wasn't his decision, the consent that he gave to the contract wasn't based on the confidential relationship or the advice he got from the person he owed in confidence. He also got an external and independent advice. Also, in the case of Alcard and Skinner, undue influence was rebutted on the ground that there was affirmation for 6 years after the influence had ceased. Okay? That after 6 years, the person came back. It was actually a case of a lady who has been worshiping in a place before. And so she moved, and when she was worshiping in that place, she gave the worship center, it's a religious center. She gave them a property, but then subsequently she moved to, after 8 years in that religious establishment, she moved to a Catholic church, and after 6 years, she came back to claim. Or then the position of the court was that undue influence will be rebutted on the ground that there was affirmation for 6 years. And after 6 years, he left. It was as if he has been affirming that he has affirmed what he had given to them. Because within that 6 years, he was not unduly influenced again. He had gained, it was assumed that she must have gained herself and not being under the influence of that religious center. And that for that 6 years, he ought to have come back before he came to court after a long time of 6 years. Also, it's good to look at the case of National Westminster Bank PLC and Morgan. You see that in Cheshire and Five Folds. Also in the case of Isiaka Lawal and Awuyemi. You can also see the case of Nadoze and Dizengoff. Please read all of these cases for clarity and better understanding. Also, it is good to know that this undue influence cannot be presumed in a relationship of husband and wife. So let's look at unconscionable bargain. Unconscionable bargain. So the term unconscionable bargain applied to a selection of cases in which the court were asked to set aside a contract on the ground that it was very unfair. It was very unfair. Anyway, I also put this in bold that unconscionable bargain will always be seen as a bargain that is manifestly unfair, that is oppressive, and that is onerous. And so these are the factors which appear to have most of the influence. Okay, anyway, factors which appear to have influenced the courts in their conclusion that the contract should or should not be set aside include the following factors. The court will look at the substantive unfairness of the contract. The court will look at the unfairness in negotiating the process. The court will look at the weakness or disability on the part of the person seeking to enforce the contract. The court will also look at wrongdoing on the part of the person seeking to enforce the contract. The court will subsequently look at the lack of independent advice. So if there's no independent advice, then the court will also see if that's unconscionable dealings claim can fly. So the concern of the court so far for fairness of bargain is not recent. It has always been seen in the time past, and it has been established in these cases. The cases of Evans and Lewelis, the case of Fry versus Lane, and so on. But Lord Denny attempted to bring all these cases under one coherent doctrine, and he called it inequality of bargaining power. Inequality of bargaining power. Okay, and so that is why Lord Denny, in the above listed thing, has classified the doctrine into 5 and attempted to comprehensively define them. So the principle of unconscionability was applied in the Australian case of Commercial Bank of Australia against Amadeo. So you will do well to do a good reading on it. Now, there are All cases under unconscionable bargain, which turned on infirmity of one of the party, it is doubtful if an English court would not set aside a transaction, mainly because one of the parties is poor, ignorant, or where they are weak-minded. So the plea failed in the English case of Portman Building Society against Dongsang. All right. But then I'd like you to just do a good read. A court in Ireland set aside some contract based on the ground that one of the parties was poor, ignorant, or weak-minded. You will see that clearly in the case of Buckley against Iwin and the case of Nope against Bell. All right. But the case was not actually applied in the case of African Songs against Adewumi. So, so that you can better understand this, I gave you a material. Ensure you read this material very well and do like a summary of it. All right, thank you. That will take us to the end of the class. But then that doesn't stop us from doing more of this in the class. So when we do get to class, it's just like trying to make you understand it better. You know, by the time we come to class again, we do another thing of an overview. Questions and answers will be taken. We'll be able to do a good conclusion on it. Thank you. Bye.